Hello everyone, welcome to Redbus News channel. In this video, we look at the latest press release by USCIS regarding adjustment of status and how what is changing and what is this policy memo about. There's been a lot of panic among a lot of people about this. So we'll try to outline whatever we know so far and give an outline of the background and everything. So that's what we will do in this memo. So this is what we'll cover in this video: a background, what is actually changing, and how it will work, and maybe whatever we know so far. This is actually very very new, right? So this is what we'll cover. If you want to subscribe to our channel, do subscribe for getting regular updates. So this is the actual press release that was done by USCIS on May 22nd. As you can see, it's a pretty significant, I would say, a policy change because this is a huge number of applicants who are actually doing changes to adjustment of status. It's one of the biggest ways of getting a green card. By staying in the US, so it impacts a lot of people. That's why it's a significant one. And there's a lot of confusion and panic among many. So that's what we'll try to and look at it more in detail, right? So just to set, I would say so that everybody on the same page, right? So what is adjustment of status, right? Adjustment of status is nothing but it's a final step to get a green card, and this happens when you're within the US. So usually when a person is trying to you enter into America for, let's say, studying or working, whatever, right? And then after that, or even whatever it could be the reason, right? And let's say, and then you apply for a green card. The last step towards that is actually filing something called an adjustment of status. You file using something called a form I-485, and this is an alternative to getting the same process done and a consular processing, like similar to how you would get a visa. So there are two types of visas. One is immigrant, non-immigrant. So non-immigrant visas, work visas, temporary visas, all of these, right? So you go and get a visa stamping to go to America and study. Similarly, there is also an immigrant visa that you actually can get abroad to enter America on, then say get a green card. So that is so essentially I-485 or this adjustment of status is for somebody who were planning to get the green card by filing within the US, right? And this is authorized as part of INA 245 and all of that, right? So, and what it does is, when you file I-485, you get EAD and travel permit and all of that, and these are adjudicated by USCIS. On the contrary, when you file the consular processing, this is done from outside the US, and there is an interview, and you have to go back to your home country, and then it is done by Department of State. So that's the fundamental difference, getting a green card with adjustment of status versus non-adjustment of status. And usually, if you're an employment-based, and usually the process for filing an adjustment of status is basically after you get I-140 approval, which is filing an immigrant petition, and then if a visa number is available, right? And also when you file for adjustment of status, you also get something called an EAD to work in the US, and also you get advance parole to travel, actually travel document. So that, this just to set, the record straight for everybody who are not sure what's happening, right? And what has happened, right, with this memo or the policy that US has released is impacting adjustment of status only. It is not impacting change of status. You see people get confused between change of status and adjustment of status. Change of status is something where you are in one visa type and changing to another visa type. Let's say you entered in US and F1 visa to study, and then you are filing to move to H1B. So that is called change of status. So the memo does not impact anybody with change of status. You can move from F1 to H1B or H4 to H1. All of these things are possible, technically. So that's not impacted. So what we're talking about is primarily for targeted towards adjustment of status applicants who are trying to in the last step of the green card, right? So that's what is the change, right? And what they're saying is this is going to be like administrative. We'll get into the details, right? So that's the idea. Now, what are the key highlights of the memo, right? The memo is, on paper it says May 21st, but the press release came on 22nd. So what it says is adjustment of status is now treated as administrative grace and not an entitlement. Basically, what it means is that it is up to USCIS and it's up to the discretion to give you an approval for adjustment of status. It is not an entitlement, like, okay, you applied, you have to get it. No, they can say, okay, XYZ things are positive, XYZ things are not positive. So, based on our discretion, we think, we're not going to give it. For example, let's say a person has a DUI, for whatever reason, right? And then they say, oh, you know what, you got a DUI, so I don't think you're going to be a good citizen in America, so you're not getting a green card, get a green card. So that is something called discretion, right? And consular processing is now where and they're saying that with this memo, this adjustment of status is an administrative grace. So it's basically completely discretion up to them. And it's not something you can expect. and they say that consular processing is going to be the default and ordinary route that you would have to take. It doesn't change the statute, but only how the discretion is applied is what they're talking about. And again, this is basically a policy memo. It is not a regulation, so there is no comment period as such. There is no rule making. All of these are not there, right? So basically, that's the whole idea of this, right? Policy memo. Now, if you look at the policy memo, it's a pretty six-page document rather, right? And these are all whatever you see on the screen are the list of uh, legal cases or the supporting cases or opinions that they refer to, which is in a different context, but depending on how you interpret it, right? So these are all of them that they matter of blast, all of these particulars, all of these are the cases that they refer to in the policy document, stating that hey, this is a discretion and it is not entitlement. Again, some of them were very contextually different. Maybe we'll do another video on all of these, how weak the case is. But again, these are the cases that are being part of it, for your information, right? Line. That's what they refer to. Now, one fundamental thing, if you notice, is like there are two things. One is the press release, and the second one is the actual memo text, right? So the press release says only in extraordinary circumstances, but there is no phrase of that in the memo actually, right? They talk about the context of it in here places, but it's not exact same. So, and it says you must return to home country to apply, but in the memo it doesn't say that, right? Like again, it's strong. Basically, press release is very much a political statement, right? It's intended to create panic among immigration communities. So that's why you see the statements are very, very different, and it's a more political statement. But if you look at the memo text, it's not as exactly like that. It's kind of, like I would say, not exactly like the press release, but it says it doesn't talk about removing of adjustment of status. It just talks about that it's much more discretionary, right? And they will look at it in a totality of circumstances. So that's a fundamental difference in the press release versus, because press release is not a legal document, and memo is something that is what is somewhat they use, for looking at some of these things, right? So that's why it's something very important to notice. Now, also there is an important thing, right? Based on the memo, when discretion comes into the picture, what the whole idea is, the discretion is basically like, again, it's up to the officer who is doing that, right? So what we believe is that the dual intent visas versus non-dual intent visas, will the risk is different, right? So, for example, for dual intent visas, dual intent are visas where you can basically, when you enter the country itself, you can have an intent to stay back. For example, H-1B is a dual intent visa. You can come to work in the US and also get a green card. But on the contrary, F1 visa is to study. It's a non-immigrant visa. There is a non-dual intent. There is no dual intent here. So you come in, you study, you have to go back. So you see H1, L1, all of these are dual intent visas, but F1, J1, TNs, E3s, O1s, B1, B2s, all of these are actually non-dual intent visas. And the fundamental difference, why this is important is because, let's look at discretionary factor, right? Okay, if legally or discretion, if I were to be the somebody officer looking at your case, you know what, you came on H1B visa and you had an intent to actually settle down. So you worked and then you applied. So, it's kind of clear. But now when you look at a non-dual intent visa, you know what, you came here to study. Now you have to go back, right, as per your visa. But why didn't you go back? So there is a discretion element there that they can say, to basically outweigh that. Why didn't you go? Is there something that's important or something that is beyond your control? Why you didn't go back? Or all of these. So that's why there is a chance of factors. You have to have X number of positive factors in discretion, in order to outweigh the negative factors, right? So that is why dual intent visas have a lower risk compared to non-dual intent visas. So that's why this is a fundamental target. Essentially, these are primarily, like for example, someone enters America on a tourist visa and then tries to get a green card by marrying an American citizen, right? So this is something that they do not encourage, and this is something which is high risk, because even anybody applying for marriage-based green cards also go through this process, right? So they're trying to weed out all some of the loopholes that are used. But again, it's a blanket one at the moment, so we don't know how they'll apply. But this is the kind of risk assessment that we have. So just to give you a perspective, right? Like for example, you see positive factors, right? Discretionary factors, what an officer would look at. You've been in the US for a long time. you're a serious hardship to family if you leave. You've been consistently living. You're paying taxes properly. You have good moral character. No DUI, nothing. All of these are positive factors. Negative could be you overstayed. You had unauthorized employment. Or you failure to depart at the end of your term. You have some arrest, or you choose to AOS when consular was available. Like for example, there's no wait time, and you choose to do that. So all of these, this again, this is not a comprehensive list. Just to give you some positive and the negative factors what they could weigh in. And this has been something now. Discretion has been this term, and this has been used in across quite a few applications nowadays, to deny some of these cases or get more supporting evidence. This is what we're seeing as a in terms of number of cases that are getting RFEs and all of that. So that's what they look at, right? Now, looking at impact of H-1B, L-1, employment-based green cards, right? H-1s and L-1s have the strongest case because there is dual intent protection from Congress. And this is actually like going to impact more Indians because they're the most of the backlog people. And again, filing a perm I-140 is not affected, but you have to be very careful. You cannot have an overstay, you cannot do unauthorized work. All of these again, these are pretty standard what has been doing, right? But the problem is if you are an O on all these kinds of visas, then you should try to switch to H1B. I mean, these are some of the suggestions because at the moment this is a very because there is no interpretation. This is very subjective. There is no clear guidelines on how they will apply all of these things, how they will plan. So again, we'll only see with time how they're going to interpret this and how what will come out. But these are some of the first impressions based on our analysis and based on some of the attorneys' analysis. We're trying to give this information, right? So essentially, if you're a non-immigrant visa or a family-based apply green card applicants, your F1, J1s, all of these basically are at higher risk because you need to really prove or tell them that okay, what are the extraordinary circumstances that you could not leave the country at the end of your term and enter on a green card. So that's why you need to really there may be heightened interview review and all of these things that you will have to see. So what is unknown is also it does not specify who all it applies to. There is no start date, end date, all of these, right? So all we can assume is that if you're already approved, you're fine, but we don't know if it'll apply to pending cases or not. This is something we don't know. So pending I-485, they may apply. So because all of these are still developing, so we have no clue all this, right? So if you have, if denied on discretion, then you also would be in trouble because your EAD, all of these could also in trouble, right? So some of these are still developing. So we don't know how this will impact. We're assuming that it will actually impact the pending cases as well. And also some of the people who will be adjudicating, we don't know how they'll apply all of these things. So this is kind of things right now we don't know. And we there is no category specific rules that have been announced, right? So we can expect legal challenges. Definitely they're coming. I'm sure people are working on this at the moment as we speak to come up with something. So we'll have to see how that will work. So what you should do now, right? Because this is now out. So firstly, don't panic, right? When you panic, you're going to be in making some bad decisions. So do not panic. Adjustment of state is not gone totally. It just says that there will be more scrutiny on your adjustment of applications, why you didn't, exit when you're on certain visas. So I think work with your attorney on what we can do. So, or maybe wait until some of the dust settles down and more guidance is given, or maybe what do you call a lawsuit is filed and then something can happen. So work with an immigration attorney, or if needed, go to a third-party immigration attorney, get advice, maintain lawful status, do not travel. And always keep look at the discretionary packet, look at what all you can create in terms of supporting evidence, positive discretionary factors. And if you're not in a non-dual intent visa, try to move to a dual intent visa. So that you have that better option, right? And you don't have to stop iPhone for all of this can continue. They're not affected by the memo, right? And again, litigations will come in. I'm sure there are. We're talking about a few 100,000 people who are going through this process every year. So consulates do not have the capacity to handle because they're already backlogged with so many pending cases. And now adding this big chunk of over 500,000 cases, to them is going to be a huge thing. So again, definitely there's litigation coming. We'll have to see what will come, right? So in short, some FAQs on this, right? It is adjustment is bad. No, no, it is not. It's legal. It just raises the bar for discretion, so you have to be very careful on that. And should you file a I-485? Again, if your priority date is current, you do have. It's better to file, or maybe pause or talk to your attorney and make a decision until the dust settles down. Then you can actually file the case, right? And if you're an F1 OPT, talk to an attorney and this see what is the path forward, right? Like H1B, all of that, right? So if your green card is approved, will this be impacted? No, definitely no. This is not. This is just a memo for I-485, not for green cards and all of that. So this is some of the common FAQs, right? And in terms of timeline, what to watch, right? The policy memo was issued at 21st. 22nd is when they release a press release. It's effective immediately for all new pending cases. That's what we're assuming. We'll see more guidance. We may expect more guidance coming in the next weeks. And coming months, we may see more lawsuits around. And some of these things we will only know with time. I mean, this is one of those things from last Trump administration term where they had this public charge rule, where they had a huge thing that came through, and there were a lot of forms that a lot of things were put together for the public charge, but eventually that was all taken out, and not many were impacted, if in employment based at least, right? So this is one of those things we see. We'll keep you posted how the things will go. So that's it, folks. Thank you for taking the time to watch. Do like and subscribe. It means a lot if you subscribe. It will help us share the message, right? So subscribe and do comment if you have any questions. We'll try to answer as we can. Thank you for watching again. Bye.